Happy Ash Wednesday 2025, years after Jesus. Welcome to the Republican Professor Podcast. I'm your host, Dr. Lucas J. Mather. I also have a master's degree. My first name's Luke. Dr. Phil, Master. Yes. I am excited today to come at you with more of Morrison versus Olson, the Dissent by Scalia. We're going to hit Roman numeral 2 today, like Rush Limbaugh always used to do with the papers. Remember that? I'm on a Rush Limbaugh kick, and I miss that guy. Let me guess, you want to follow along? Well, let's help you follow along. If you want to follow along, I'm not gonna keep you from following along. We're gonna go to Google Scholar, and we're going to search. This is my favorite to do. Case law, federal courts. I got to share my screen. You know the joke by now. Go ahead and call me Sharon. You go to case law, you go to federal courts. Then you go to Morrison versus Olson. Not that hard. Clicky little wiki. Do a control F, dissenting. Just go down to Justice Scalia and scroll down. There's Roman numeral 1. We did that last time. Roman numeral 2. Roman numeral 2. Here we go. I think we I think we did Roman numeral 1 last time. I better make sure. Hold on. Hold up. Yahoda. Yahoda. All right. I was right. We are going through Roman numeral 2. I don't know if you remember last time we did end with just a brief quotation from the very beginning of Roman numeral 2. So that's why I had to pause and make sure. Okay, if to describe this case is not to decide it, the concept of a government of separate and coordinate powers is no longer has meaning. The court devotes much or most of its attention to such relatively technical details as the appointments clause and the removal power. He's talking about the court in their majority opinion in this case, which he's dissenting from in 1988. Kicked and scratched and pulled my neck in 1988. As my prologue suggests, I think that it has it backwards. We're on 704 now, page 704, right here. Our opinions are full of the recognition that it is the principle of separation of powers. Oh, I love that phrase. Separation of powers. Yeah. And the inseparable corollary that each department's defense must be made commensurate to the danger of attack. Federalist 51. I don't know why I'm on a Rain Man kick. I'm like on a Rain Man kick. I'm on a Rush Limbaugh kick here, which gives comprehensible content to the appointments clause and determines the appropriate scope of the removal power. Thus, while I will subsequently discuss why our appointment and removal jurisprudence does not support today's holding, I begin with a consideration of the fountainhead of that jurisprudence, the separation and equilibrium of powers. First, however, I think it well to call to mind an important and unusual premise that underlies our deliberations, a premise not expressly contradicted by the court's opinion, but in my view, not faithfully observed. Again, this is Justice Antonin Scalia dissenting in Morrison versus Olson, 1988. Kicked and scratched and pulled my neck in 1988. It is a rare, it is rare. Where are we at? It is rare in a case dealing, as this one does, with the constitutionality of a statute passed by the Congress of the United States, not to find anywhere in the court's opinion the usual, almost formulary caution that we owe great deference to Congress's view that what it has done is constitutional. That caution, hold on, he's citing a bunch of, let me make sure this is, okay. That caution is not recited by the court in the present case because it does not apply. That is very insightful of Justice Scalia. Where a private citizen challenges action of the government on grounds unrelated to separation of powers, harmonious functioning of the system demands that we ordinarily give some deference or a presumption of validity to the actions of the political branches in what is agreed between themselves, at least, to be within their respective spheres. But where the issue pertains to the separation of powers, now I'm on page 705, and the political branches are, as here, in disagreement, neither can be presumed correct. The reason is stated concisely by Madison, and here he's quoting Federalist 49. The several departments being perfectly coordinate by the terms of their common commission, neither of them, it is evident, can pretend to an exclusive or superior right of settling the boundaries between their respective powers. The playing field for the present case, in other words, is a level one. As one of the interested and coordinate parties to the underlying constitutional dispute, Congress, no more than the President, is entitled to the benefit of the doubt. To repeat, Article 2, Section 1, Clause 1 of the Constitution provides, the executive power shall be vested in a President of the United States. As I described at the outset of this opinion, this does not mean some of the executive power, but all of the executive power. It seems to me, therefore, that I think what he means there for you logicians is he means part, but not all, versus all. If you know, you know. It seems to me, therefore, that the decision of the Court of Appeals invalidating the present statute must be upheld on fundamental separation of powers principles if the following two questions are answered affirmatively. One, is the conduct of a criminal prosecution and an investigation to decide whether to prosecute the exercise of purely executive power? Two, does the statute deprive the president of the executive of does the statute deprive the president of the United States of exclusive control over the exercise of that power? Surprising to say, the court appears to concede an affirmative answer to both questions, but seeks to avoid the inevitable conclusion that since the statute vests some purely executive power in a person who is not the President of the United States, it is void. Surprising to say, the court appears That is the court in this case. Remember, he's dissenting. So the court opinion is a different opinion. The court appears to concede an affirmative answer to both questions, but seeks to avoid the inevitable conclusion that since the statute vests some purely executive power in a person who is not the United States, it is void. That's a key part here because Scalia is saying, I'm not going to make that mistake. The court made this mistake. I'm not going to make the mistake. The court really should have been saying what I'm saying. Of course, all dissents say that, but he's saying it very powerfully here. The court concedes that there is no real dispute that the functions performed by the independent counsel are executive, though it qualifies that concession by adding in the sense that they are law enforcement functions that typically have been undertaken by officials within the executive branch. The qualifier adds nothing but atmosphere. Page 706 now. In what other sense can one identify the executive power that is supposed to be vested in the president unless it includes everything the executive branch is given to do? Wow. Except by reference to what has always and everywhere been conducted by government at all. Been conducted never by the legislature, never by the courts, and always by the executive. There is no possible doubt that the independent counsel's functions fits this description. She is vested with the full power and independent authority to exercise all investigative and prosecutorial functions and powers of the Department of Justice and the Attorney General. Governmental investigation and prosecution of crimes is a quintessentially executive function. I'm going to the next page of my printout, and we're continuing. It's a little bit longer of a section here. We might have to break this up into two because we've got 3 big pages of reading here, but we'll do the best we can. All right, I'm going to switch sides so you can see the rest, the other side of my time. Okay. I'm looking out for you guys. I know that it's hard to have an attention span when so much is happening, on TalkTick and whatnot. So you might want to see what kind of tie I have on. This is a very nice steel gray. It's gunmetal gray, and there's little blue circles on it. You maybe can't tell. The blue, of course, matches perfectly my jacket here. The gray is a nice calming effect. Of course, you have a pure cotton shirt here. I'm not sure the thread count, but it's a very nice cotton shirt, 100% cotton. It's one of the very few shirts that I own that is over $100. And I got this many, many years ago, and it has served me well in many, many classrooms since then. I got it from Roger Stewart Clothes in the Fashion District in LA. All right, let's keep going. Roger, you owe me some money. As for the second question, whether the statute before us deprives the president of exclusive control. Exclusive control over what? Purely executive functions. Over that quintessentially executive activity. The court does not. and could not possibly assert that it does not. That is indeed the whole object of the statute. That's the independent counsel statute. Came out of the Watergate years. Instead, the court points out that the president, through his attorney general, has at least some control. That concession is alone enough to invalidate the statute. But I cannot refrain from pointing out that the court greatly exaggerates the extent of that some presidential control. Uh, I think I would like to clean up a little bit of the logic here since I taught logic for so long. I think it would be better for him to say that the president having some control doesn't invalidate the statute. Rather, the the um, the statement that there's some aspects over which he does not have control. That is the O statement in the Aristotelian square of opposition, not the I statement. You don't want to lead with the I statement. You want to lead with the O statement. There's some executive actions that are not in the president's control. That's that's the problem. That's the problem. Okay. Um, and if you don't understand what I just said, take logic. You might want to take it from me someday, somehow, some way. All right. So here we go. Um, Most important among these controls, the court asserts, is the Attorney General's power to remove the counsel for good cause. This is somewhat like referring to shackles as an effective means of locomotion, one of the more famous quotations from this. As we recognized in Humphrey's Executor versus United States, indeed, what Humphrey's Executor was all about, limiting removal power to good cause, is an impediment, if not an effective grant of presidential control. We said that limitation was necessary with respect to members of the Federal Trade Commission, which we found to be an agency of the legislative and judicial departments and wholly disconnected from the executive department, because it is quite evident that one who holds his office only during the pleasure of another cannot be depended upon to maintain an attitude of independence against the latter's will. What we in Humphrey's executor found to be a means of eliminating presidential control, the court today considers the most important means of assuring presidential control. Congress, of course, operated under no such illusion when it enacted this statute describing the good cause limitation as protecting the independent counsel's ability to act independently of the president's direct control, since it permits only removal only for misconduct. All right, I'm getting some chat. Okay, I got some Q&A. The Q&A is about my pens. I appreciate you asking. This is a CRPA pen, California Rifle and Pistol Association. It's a 140-year-old entity in the state of California, California Rifle and Pistol Association, CRA.org. Check them out. Join. They have a fantastic magazine, professionally produced. And this other pen, I do have, always have two pens. This is a Skillcraft U.S. government pen. It's what I prefer to fill out any form or any check. If you know what a check is, writing a check, sometimes the ink smears because it comes out too much, and sometimes it doesn't come out at all. The Skillcraft U.S. government pen I've been using, well, since I was active duty in the United States Navy. This is what we used to fill out forms, and it's still really, really good pen. Um, it has just the exact amount of ink that you need, and it fits in your pocket like this. It's the signature blue and sorry, black and silver. It's black colored pen. I think you can get them in blue. Um, but this CRPA pen is also in black, but it's got a blue exterior and a really nice, comfortable cushion for your fingers if you're writing notes. I really love this pen. The tagline is "Be safe, shoot straight, and fight back." That has to do with fighting back politically, FYI, for all those who pretend to still be traumatized by January 6th. Okay. Be safe, shoot straight, fight back politically. CRPA.org. That's the California Rifle and Pistol Association. Check them out. All right. Back to our regularly scheduled programming. Rush Limbaugh. Here we go. Moving on, and I know you wish I would move on, but we have to cover this. Moving on to the presumably less important controls that the president retains. Okay. Moving on. The court notes that no independent counsel may be appointed without a specific request from the Attorney General. As I have discussed above, the condition that renders such a request mandatory, the inability to find no reasonable grounds to believe that further investigation is warranted, is so insubstantial that the Attorney General's discretion is severely confined. And once the referral is made, it is for the special division to determine the scope and duration of the investigation. Wow. And in any event, the limited power over referral is irrelevant to the question whether, once appointed, the independent counsel exercises executive power free from presidential control. There you go. There's the I statement. Is there some that is not? Some A that is not B? Yeah, that's the issue. Okay. It's the some are not categorical statement, not the some are that he needed to have in there. He found it. Okay. All right. So, hmm. In any event, the limited power over referral is irrelevant to the question whether once appointed the independent counsel exercises executive power free from the president's control. Finally, the court points out that the act directs the independent counsel to abide by General Justice Department policy except when not possible. Oh my gosh. What could possibly go wrong here? What could possibly go wrong when not possible? Wow. The exception alone shows this to be an empty promise. Even without that, however, one would be hard to put to come up with many investigative or prosecutorial policies other than those imposed by the Constitution or by Congress through law that are absolute. Mm-hmm. Yeah, makes sense. Makes sense. Almost all investigative and prosecutorial decisions, including the ultimate decision whether, after a technical violation of the law has been found, prosecution is warranted, involve the balancing of innumerable legal and practical considerations. We're on page 708, if you're following along. Indeed, even political considerations in the nonpartisan sense must be considered, as exemplified by the recent decision of an independent counsel to subpoena the former ambassador of Canada, producing considerable tension in our relations with that country. Another preeminently political decision is whether getting a conviction in a particular case is worth the disclosure of national security information that would be necessary. The Justice Department and our intelligence agencies are often in a disagreement on this point, and the Justice Department does not always win. The present act even goes so far as specifically to take the resolution of that dispute away from the president and give it to the independent counsel. In sum, the balancing of various legal, practical, and political considerations, none of which is absolute, is the very essence of prosecutorial discretion. The very essence. To take this away is to remove the core of the prosecutorial function and not merely some presidential control. Well, that's a very interesting argument there. As I have said, however, it is ultimately irrelevant how much the statute reduces presidential control. The case is over when the court acknowledges, as it must, that this is undeniable that the act reduces the amount of control or supervision that the Attorney General and through him the President exercises over the investigation and prosecution of a certain class of alleged criminal activity. It affects a revolution in our constitutional jurisprudence for the court once it has determined that one, a purely executive functions are at issue here, and two, those functions have been given to the person whose action are not fully within the supervision and control of the president. Nonetheless, to proceed further, to sit in judgment whether the president's need to control the exercise of the independent counsel's discretion is so central to the functioning of the executive branch as to require complete control. Man, this reminds me of some of the Second Amendment stuff that I follow. That little bit about, giving the court judgment on a balancing test. It's like a balancing test. We're What Scalia is saying is a balancing test here by a court on a statute to try to assess this statute takes away or purports to take away some executive power from the president by statute. Well, and so the role of the Article 3 court here, according to that view, for the independent counsel statute at issue here, it's the same statute that prosecuted Bill Clinton afterward. That's why the Democrats stopped supporting it. They loved it when it was about Nixon. They loved it when it was about Reagan. They didn't like it when they came after Democrats using the same tool, right? The problem with the interest balancing power you're supposedly giving to the courts to weigh whether this is really important executive power. It's not so important. We can take it away from the president. We have the authority to do that. Is that it distorts the constitutional issue. Textually, originally, so originalism and textualism, textually, the Constitution vests the president with all executive power of the federal government. So that's a vested power. It's not subject to removal by the mere will of a majority of Congress. It's not really subject to removal by a supermajority of Congress through a bill. Now, it might be through the impeachment of a particular, impeachment and removal of a particular president, but we're not talking about a particular president person. We're talking about the office itself. You can't impeach and remove the presidential office. Impeachment and removal is about the person, not the office. And we're talking about taking executive power away from the presidency, not the president, whoever it is, the person. It's the office itself that Congress is nipping. We have protection for workers. We have protection, removal protection. They can only be fired for good cause. And we get to decide that. Us, Congress. And Scalia is saying, no, you don't. If it's an executive function to fire that person. And it is because it involves executive activities. And you don't get to say to the court, and the court doesn't get to say itself, we take on this interest balancing power. It's similar to the Second Amendment jurisprudence because we are victims of so-called gun control laws created by bare majorities in legislatures in many cases, or on city councils or whatever it is, board of supervisors, whatever legislative body it is. And sometimes it's courts too that are taking on a role they shouldn't take on. They're engaging in interest balancing against vested rights vested by the Constitution in individuals. The right to keep and bear arms. It's not up for legislative bargaining. It's not up for an interest balancing test by the court. That's not the kind of thing this is. It's in the Constitution. An ordinary law, an ordinary ordinance, statute, a regulation, a resolution, a even a court decision cannot take that away because the Constitution creates the whole thing. It's the bedrock. This is just basic constitutional law versus statutory law. In statutory law or in legislation, at whatever level, city, county, state, federal, the the newer supersedes the older when they conflict. In constitutional law, it's the opposite. The older supersedes the newer when they conflict. When you're talking about a statute versus a constitution. The Constitution is older, the statute's later. If they conflict, the Constitution wins, not the statute. The new does not win. That's the whole point of constitutional law. The Constitution supplies a way it can be changed, and you have to go through those processes to change it. If you want to take away the right to keep and bear arms, you've got to go through that process. You can't go through an ordinary statute. You can't go through hoping, living on a prayer, hoping you're halfway there, fingers crossed, in the Ninth Circuit. That's not how it's supposed to be done. And the same here with the vested rights of executive power and the president. That's what he's saying here. Where do we leave off? I got a little bit more, and then I'm going to stop for today. We're going to finish 2 later. Okay. Well, okay. I'm just going to, maybe I'll read something over again here. All right. Man, where did that? This is a long sentence. Holy cow. All right. I'm just going to read this whole paragraph again because I think it's really important. As I've said earlier, however, it is ultimately irrelevant how much the statute reduces presidential control. See, that's similar to what I was talking about with Second Amendment. It doesn't matter how much you infringe on the right to keep and bear arms. It's not interest balancing. It's not to say, uh, it's not that bad. Because where do you draw the line? The Second Amendment says shall not be infringed. Okay. Where's the interest balancing? As I've said, it's ultimately irrelevant how much the statute reduces presidential control. Look, I understand you want to keep the president on his toes and make him feel accountable. It's called impeachment. It's called elections. There's already a mechanism in there. And this, of course, the founders didn't put term limits on the president because why would you? He stands for election. That's a check on him if he wants to be reelected. If you give him a blank check because he can't be reelected, that's not how it works. That's not good for us. It's not good for Congress either. Judges are a different matter because of the nature of their job. It's not supposed to be political in that same kind of way. Um, I mean, ultimately, this is all political, but it's not supposed to be political in the same kind of way in the court. Um, I hope that this is making sense here. The case is over when the court acknowledges. I love this language. It's over, dude. When you acknowledge, as it must, it is undeniable that the act reduces the amount of control or supervision that the Attorney General and through him the President exercises over investigation and prosecution of certain class of alleged criminal activity. It affects a revolution in our constitutional jurisprudence for the court once it has determined that one, purely executive functions are at issue here, and two, those functions have been given to a person whose actions are not fully within the supervision and control of the president. Nonetheless, to proceed further to sit in judgment of whether the president's need to control the exercise of the independent counsel's discretion is so central to the functioning of the executive branch as to require complete control. Whether the conferral of his powers upon someone else sufficiently deprives the president of control over the independent counsel to interfere impermissibly with his constitutional obligation to ensure the faithful execution of the laws, and whether the act gives the executive branch sufficient control over the independent counsel to ensure that the president is able to perform his constitutionally assigned duties. It is not for us. See, this is the Article 3 gem here. This is the Article 3 commentary by Scalia. It's not for us to determine. And we have never presumed to determine how much of the purely executive powers of government must be within the full control of the president. The Constitution prescribes that they all are. They're vested powers, just like the Second Amendment vested rights of keeping and bearing arms. We're going to continue with the utter incompatibility of the court's approach. That's in Roman numeral 2. We're halfway through exactly Roman numeral 2. We have 2 more pages of the printout. Then we go Roman numeral 3 and Roman numeral 4, Roman numeral 5, and then Man, this is such a long piece, but it's so great. It's so rich, and I think you're going to really enjoy it. I know I have. And I've enjoyed this time with you here on Ash Wednesday. Um, God bless you guys. We'll see you next time. Today is 5 March 2025, Wednesday. Peace.